far are we from making sure that these mines open? And secondly, somebody must go to jail. I've said it last time in the last meeting that somebody must go to jail. And then, we need to understand how far are we from opening the mine. What are they doing? Because it's obviously, like we have said last time, that Vantage Goldfields are not going to give this mine up. We have said it last time, and you can see that there's no movement that is going to happen. So what is the department going to do about it to make sure that we get our mine back? Thank you, Chair. Thank you, Chair.
Chair. Chair, are you still around?
Ayanda?
Yes, Mr. Milam?
Ayanda, can I suggest that we appoint someone to act as chairperson until the chair gets back?
Do we have to go the process of appointing? Or can I just ask member to continue? Because I'm trying to call him on the phone. I don't know what happened.
With just continuing. It's not like we're taking any decisions at this stage.
Okay. Can the next member then ask the question while I'm trying to speak to Chair? I don't know what happened to him. Who's the next member to ask a question?
No member was appointed, Ayanda, by the chairperson to speak after Shonyani. So get him on the phone.
Okay.
Can we not just follow the normal speaking order that we use?
I suggest so, Mr. Milam.
Yeah, the next one is usually Mpumalanga.
Mpumalanga, can you continue?
This is so funny. You I follow Malo. And yes, let me come in. I don't
Sorry, Malinga. I agree that you continue, but we can't continue if the phone is ringing on our speakers because we can't hear you.
Apologies, members. Chair is got a technical problem. His laptop just frozen, so he's gonna check out and come back again.
Kuba Zwede.
Ngiyathokoza sihlalo ukubanjiswa and honorable members. You know, I was actually hoping that the chair will come back so that he hears our concern with regards to this, because the confusion that the honorable Milam is raising, I think there's a collective confusion in the portfolio committee, because it brings to the point to say, because even when you go through the presentation, you read it and then you hear Mr. Arendse speaking to it, you find two sides from him to say that what is it that he actually, because my main question will be Mr. Arendse, what is it that he actually wants the portfolio committee to do? What is the injunction of the portfolio committee to do? Because all the prevailing circumstances are of concern, I think, to all the members, because of what being ignored and moving from one investor to the other, trying to delay. Because subsequently, these proceedings just shows you that there's no intention to actually rescue those people who had passed on. So we need to collectively sit and say, this is what Mr. Arendse, from his whatever capacity that is coming on today, expect from the portfolio committee to do, and then maybe we can have a direction as to where do we actually bridge the gap, because the retrieving of the bodies is of concern. It has been quite a number of years now, since I think there's 2 terms discussing the same thing, which is of real concern. So my main question will be, what is it that Mr. Arendse coming to the portfolio committee would want the portfolio committee to do, as there's no injunction at the from the portfolio committee to do anything with regards to this. Thank you, honorable members.
No, I heard you. I was hearing the whole conversation. The only thing is that I was refusing to unmute, and so no, don't worry. As a chair, I heard what you said, but this is a matter of the committee. That's what I can say. Honorable Bilangulu. Do you have any take, Babu Bilangulu? Okay. Is Honorable Fulmarans in?
Why are you speaking with us?
Is Honorable Fulmarans in? Mpumalanga?
He's got a network problem, Chair. He's still busy trying to connect.
Okay. Honorable Tenjan.
Yes, thank you very much, Chairperson. Once again, thank you very much also to Mr. Arendse for a very, very nice and mouthful presentation. I will say this to some of us who have been following this matter almost when it started. Now, being the fact that it happened in Mpumalanga, which is the place where I come from. I know this matter where it started. Luckily, as a member also of this committee. Now, indeed, all what Mr. Arendse has said, it makes a lot of sound. It is correct, the issue of the community, the issue of the chief and the consultation and all those things. But be whatever it may be, remember this is a committee where clarity needs to prevail. We need to get the proper clarity as a committee, of course. Now, there is a genuine question here, which I think was asked by the other speaker. It is indeed, Mr. Arendse, it is indeed a genuine question, because this committee needs to know exactly which company are you representing, I mean. Because there was an involvement of Fleming Silver, and then Fleming Silver didn't make it because of the opposition and all those things. And then there come Aquamanzi with Taung. I mean, there come SCC with Taung, which merged and became one company, which is now Aquamanzi. Now, also, there was also another very good relevant question, which is asking that which you are involved also with Vantage. Now, as you are involved in Vantage, now it brings a lot of confusion here. It did before, and then now it still emerged. There is a lot of confusion also here as to where are you standing? Where is your standing point? Is it not this thing that is causing all this confusion also? Because we come to find out that whatever that you are trying to do is getting opposed by Vantage. But also we find that now there are a lot of, you've been involved with different kind of companies. And then we want to know which one is the proper. Because now there is an issue of a Section 11, which according to you, even got lost in the offices of the DMRE, if we heard it correctly. Now, also the question will be, which company exactly did the Section 11 between Fleming Silver and Agomanzi? We want to know which one exactly that's got the title of the Section 11. Now, going forward to the families now. Yes, we understand in all the commemoration that are happening there, you are there as a person because we are always sometimes there when it happens. Now, as I want to check with you, will you explain to this committee what will be exactly your interest? Is it to retrieve the 3 bodies which are still trapped in that mine? Or is it also for you to also make money, just to make money? And then what is your interest? Can you tell us here the real reason for you to rush to open this mine is to retrieve the body, or is to retrieve the body while also doing production? That we also need to know as a committee, because we need to know exactly if we come with an assistant, what are we assisting here? Because at the end of the day, it is our community and the families, the village.
Thank you, Mom Tenjan.
Okay, okay, thank you. Thank you.
If you get time, you'll come back again.
Okay, thank you, Chairperson.
Honorable Phillips.
Good morning, Chair. Thank you for the presentation, Mr. Arendse. Yeah, what you've presented is very confusing. I think we're just as confused now as we were actually before the presentation. So my question is, what actions would you propose, and what is the and what would be the way forward? And then what do you want the committee to actually do to help resolve this issue? Thank you so much.
Honorable Kula.
No, thank you, Chairman. I must say that I'm quite confused about the multiple caps that are worn by Mr. Arendse, which creates a confusion of who he represents today. My major concern is that because the issue is before the courts, what intervention is Mr. Arendse seeking from the portfolio committee? That is my only concern, that because the issue is still before the court, what are the interventions that is seeking from the committee? Thank you very much.
Okay. Thank you, honorable members. Let me first maybe try and unpack some of the issues. You will recall, honorable members, in the previous presentation, we had a letter written by Mr. Arendse when we invited the business review practitioners, the department, and the CEO. I've explained the first letter of the CEO and what we have now. In the letter, he requested that he wanted to come as a CEO of the company that was buying from Vantage. And what we stated was that it will be difficult because the main focus of the committee is on the incident that happened at Lilly 9, not a commercial transaction. But it was also stated that he is a director of VGL. And on those bases, we said we can't prescribe who should represent the company. We will only deal with the matter when they are here, when they are in front of the committee, and they both, and as directors, they then have a difference of opinion. But we couldn't invite Mr. Arendse, none other than. So if he had come as a director of VGL at that time, he was welcome. But the committee felt that he was raising issues that the committee has to hear now as the CEO of another company. I don't want to talk about the companies because it might sound like you have got too much knowledge, and the question will be why. As a CEO of that company, we said we will give him an audience when we take the oversight to Lilly Mine in Mpumalanga and Optimum. But unfortunately, the lockdown came in. We then agreed that rather than to wait for the time to go to Mpumalanga to Lilly Mine, let's invite him, and so that he can present his side of the story. My main issue, which I think is what members on Mr. Arendse will understand, is that from a commercial point of view, the transactions and what the department, what your company has been frustrated on, I think that's what members are saying. It will be difficult for the committee to deal with transactions. But as far as, which is what we also interested, and we think some members were trying to highlight, is more on the issue of what could be done and what is best that could be done. Maybe to add for me to the questions that I think members, because I was just responding on behalf of why we invited you, that this time around, we didn't invite you in your capacity as a director. We invited because at that time, if I remember, your letter was saying, no, you wanted to come as you are not invited as a director. You said, we can't prescribe, if a director comes to the committee, you can't prescribe who must constitute the delegation to a committee meeting. But for our interest, it was with the company itself that we feel it was responsible for the incident. It was with the department as well as the business rescue practitioners at that stage. But having said so, maybe what will try and clarify this confusion, because to me, what becomes a little bit of a concern is, when did you join as a director of VGL? It's important because if I listen properly, it seems you joined when the company had, or when the incident of the 3 employees had taken place. And the question would be, what was the logic with you joining a company that was already in a state of, in my view, in a state of crisis? Secondly, I think you will assist. Can you clarify the relationship in terms of the cost application and the decision? Who is supposed or has got a final order? As far as you know, as a person who has been doing this thing, because there's the 100% Australian-owned Vantage Gold, there's the South African part of it. Whether by addressing the issue with South African component of the company, does that make you qualify in total for the issue of the purchasing arrangement? Or is it a matter that, because I hear that it seems there is a demand of a certain percentage or a certain amount, who is putting the price for the mine, so that we can deal with that? Thirdly, according to your own knowledge, can you help us to understand that as part of the directorate or directors of that company, if you are, or as part of the purchasing company, what is the problem? Because I think what confuses members is that we're not sure. At that point, there was a suggestion that said the same company that the department would have found guilty, it's supposed to have taken them to court, it's supposed to have taken extraordinary measures, is the same people who are asking for an amount of money. It means they want to benefit out of this sad incident. We want you to be categorically, so that as a person now who has raised, we understand your frustration. We are not that unsympathetic, but we are more sympathetic to what we think is a matter for the nation to take cognizance of. What do you think is the real problem? Is the real problem that could lead to retrieval of those bodies satisfying the same people that would say, I'm saying it in inverted commas, are responsible for the state of crisis we are in today? Is that what you think is the matter? And there is an argument that was raised that said the reason is that if you retrieve the bodies, then you will be bringing in evidence on surface. What's your take on that? I think if you can answer those questions so that from where we sit as a committee, honorable members, there is nothing except commercial. But the incident of Lilly that happened, it remains a responsibility that us also as representatives of the people have to take charge of and do something which we have to find as reason. What is it that we could do? But I can give you, Mr. Arendse, to give a response, please. Just mute again. I hope you are not affected by what affected me. Are you there, Mr. Arendse? Okay, DG.
Hello, Chair.
There were questions that were related to the department in as much as you had not presented. And I think there is one critical point that, if I'm not mistaken, Honorable Bailam and to some degree Honorable Kola have raised in the whole issue of confusion. The question of how do you make sure that this is a very clean process, but also what's your take on other matters that were raised with the department? Whilst we are waiting for Mr. Arendse.
Thank you very much, Honorable Chair. Good morning, honorable members. As you know, Chair, that as a department, we are guided by the law, we are guided by the rules and regulations, and the department is a regulator in this instance, and so we will be required or expected as a department to make sure that we execute our mandate in line with the applicable prescripts. And so that's what we have done. That's what we continue in our doing. For an example, Chair, in terms of the question of what did we do as a department, you remember that there was an inquiry that was conducted and we presented this to the PCC this year with recommendations of what is expected, to happen. Now, out of that, Chair, we have further confirmed that the department played, a role in.
Sorry, can someone somewhere be what was try and just mute the mic and try and see there's a lot of background noise where you are, or somebody else might be having the mic on also. It's like there's a radio that is in off station, in a wrong station. You are trying to find a frequency for the radio.
Okay, no,
But
thank you very much.
continue.
Thank you very much, Honorable Chair. I tried to put a headphone, perhaps it will be better. Now, as I was saying, Chair, trying to explain that as a department, we have been involved in this process from the conceptual stage up to now in engaging with all relevant parties. Remember that as a department, we are guided by the rules as well as to how far can we get involved. We can't be seen getting involved on transactional issues between private parties. Now, we must play our role as a department, but we understand that, the frustration, it is really, now getting into all of us. But we have to make sure that there is actually a compliance with the law. Now, going back, without wasting your time and honorable members' time, Chair, we received a Section 11 application. That's where we need to start as our role as the department. Now, we had to process that Section 11. We processed it within a very short space of time with the understanding that this matter needed to be dealt with and concluded immediately. Now, then post that, the parties then took each other to the courts. And so once the parties are in courts, and so as a department, our role is limited. We can only talk to the parties to request them that try to have a settlement, as we have done, have out-of-court settlement in resolving this matter, because if you take this matter to the courts, it may even end up at a constitutional court, and so it can take even close to 10 years. And so that had been our role as a department, as a regulator, because we must also be very clear as to how do we get involved in this process. But we continue to engage all the parties. Even recently, 2 weeks ago, we had a meeting with the BRP together with Mr. McChesney, trying to bring them together to find a solution to this matter. And now we have received a report here that the plan has been published, and so we are still going to study it. But the plan was only published yesterday on the 12th of June. And so that is a role that we would be playing as a department. And it must be understood that our role is regulated. And if you look in terms of what we have done as a department, we have done more than enough in terms of making sure that we execute our mandate as a department. But other issues, Chair, I think you have raised specific questions to Mr. Arendse. If there is a need for us to come back, we would definitely respond to the questions. Thank you very much, Honorable Chair.
Is Mr. Arendse back?
Honorable Chair, can you hear me? Honorable Chair?
Yes. Yes.
You can hear me now?
Can you respond,
okay,
please?
thank you. Yes, thank you, Honorable Chair. If I can just go straight, there's a few questions which I would like to clarify and start with the first one from the Honorable Member Milan. The capacity that I'm in is as a Director of VGL. I represent VGL and I represent SSC, Flaming Silver, that has made the purchase on which the Section 11 was premised on. So those are my two capacities for this meeting. And as the Chair has clarified as to why it was felt that I must come and present in these two capacities. But just to clarify, I don't speak for Angumanji, and I'm not empowered to speak for them on this meeting, other than just so the current structure, you know, of the company that has made the bid, on which the new amended plans was published yesterday. On the second question, in terms of an audit, that was one of the concerns that I've raised, you know, as a director. And maybe I must also, you know, get to why was I appointed? I was appointed as a director in 2018. And the reason for that is we have invested substantial amount of money, close to 32 million rand, you know, since we got involved with Lilly Mine. And it was found proper that I be appointed in VGL as a director, which I'm still serving. Now, the challenge that we are having is that, yes, you know, directors has got different agendas. And I want to get to the very question as to what is my interest. And I would like to respectfully be very open about it. My interest is twofold. Number one, my interest is a commercial interest. You know, I cannot lie about that. Number two, my interest, it is actually more important. It is to get these mines back into production so we can employ the very people that relied on for their livelihoods on these mines. So that is my primary and motivated focus. And also, you know, get these mines to a profitable state so they can look up the community and to develop the community and provide opportunities to creditors. So that is my interest, you know, in this, honourable member. In terms of litigation, the honourable member was saying, but why should this matter should be taken to court? We have done that. We have done that. Hello? Honourable Chair, can you still hear me?
We can hear you.
Okay. In terms of the question of why don't I take the matter to court, we have done that, but unfortunately, with our courts, it is a very, very long process. And unfortunately, Chair, you asked the question: is that what is the issue on the board? We have parties who don't have the same interest. We've got one party, and I want to be honest about this and frank about this. We've got one party in the form of us that wants to open these mines, and you've got another party in the form of BTFA that don't want to see these mines open. And hence, I provided background to the committee so that they can understand why am I saying certain things. So to answer your question directly, Chair, that is the conflict that we're having. You've got one party that's doing everything in the best, to have these mines open, but unfortunately, you've got another party that don't want these mines to be open. And as I said in my presentation, it is for reasons what has happened on the 5th of February, but that is a matter that will be dealt with by the Director General. In terms of the mess that our Honourable Lady Member of Parliament has mentioned, I want to agree with her 100%, and hence I brought this to the attention of the committee, because this mess is a coordinated mess. And this mess, as a result of this mess, thousands of people are suffering as a result of this coordinated mess. And hence, not just frustrations. And I want to say, I do not want the committee or the department to get involved with any commercial, affairs of private companies. But the result of what we're experiencing not just affect us, but affects the very same employees that have lost their job as a result of what the Vantage people has done in terms of the accident. Now, in terms of the Section 11, there was a question. SCC Flaming Silver applied for Section 11, and the Section 11 is in the name of SCC Flaming Silver. Hence, I provided that background. So that is the answer to that. In terms of what the lady was, the last lady was saying in terms of the confusion, and I trust I've clarified that confusion. And also the Honourable Chair has clarified that confusion. I am not approaching the Honourable Committee to assist us in a transaction or getting involved in any commercial, but the net effect of South Africans and the people that suffer at the hands of the people that caused this accident. And I want to say respectfully, we didn't cause this accident. We try to open these mines. And I've said exactly as to why do we want to open, this particular mines. And the last point that I want to conclude, the Honourable Chair, is that we respectfully understand that the committee has got certain limitations, but as I have put in my presentation, this is an extraordinary matter, and I appeal to the committee to support and assist the department where possible to use the legal avenues to bring this matter to a conclusion, for the reason that the effect is not on us. We just lose money, but we're fine with that. But what we're not fine is that these delays and this 5-year business rescue process, thousands of people suffering as a result of that. And we've been trying to open these mines because that is a solution to add, to creating, employment and support the vulnerable communities. And that is our key agenda of why we continue pushing hard in what we are doing. Thank you, Honourable Chair.
Thank you, Mr. Honourable members, can I make, because of time, can I make this following proposal? At least we did, on the basis of fairness, we did our best. No party at this stage can say we have not done the work. Can I make this following proposal, and hopefully Parliament will allow that we undertake an urgent visit, probably when we open. I'm sure the regulations or the period won't be that tense. I've seen that even other committees were able to break themselves into 2 groups. I would make a request that we make an application to the House Chairperson. We break our team into two to do the work that we're supposed to do before the lockdown. Amongst other areas is to prioritize Lilly mine. Secondly, in the meantime, prior our visit, can the committee allow us, myself, and the secretariat to compile a report for discussion in the committee that will then decide what will be the way forward with regards to the issue of Lilly mine. Amongst other things will be what do we think has to be done and what do we recommend as a committee has to be done. We will look at it whether shouldn't we wait for then the, what do they call, the inspection in loco, so that it assists to have an informed report, so that we know that whatever is put on the table is an outcome that puts the matter to rest from a committee point of view. Can we agree on that? We will deal then in that discussion, we will deal with all these underlying issues in terms of the, but like all members agree, and I think it's an acceptable no. It is impossible to deal with the transaction. Ours will be to look at what are the challenges, the delays, or the stumbling blocks from the retrieval of these bodies. If the matter has got a transactional elements, how do we overcome those issues? Can we then say the matter out of the presentation is now, we are now as a committee seized with it to discuss, recommend, and take decisions? Do we agree on that, honorable member? When I grew up, they used to say silence means consent. I take it we all agree, isn't it?
Agreed.
Okay. Mr. Ari.
Honorable Chair.
Please note what the committee has agreed on. Then
Thank you.
with Ms. Bob.
Yes, thank you so much for
Yes,
that.
Chair.
I have recorded that on my notes. Thank you so much for that, Honorable Chair.
Okay. Thank you very much, Mr. Arendse. Thank you very much to the department, although it was not here. Can I now go to the department? Please bear with us. Please bear with us. We don't have enough time. We still have to deal with. I'm giving you and your business rescue practitioners up until 5-2. Because we have presented before. We only want to understand what is the status with regards to Optimum code.
Good morning again, Honorable Chair, honorable members of the PPC on Minerals and Energy, the Deputy Director General in attendance, our parliamentary support staff, as well as the BRPs in attendance, and our media. Chair, I'll be very brief. We have the presentation that we have circulated. But maybe before that, I've heard when we were dealing with the apologies earlier on, the apology of the minister was not presented. The minister is currently attending a sustainable infrastructure development symposium of South Africa. That is the reason why he's not part of this meeting. Chair, we have the BRPs. Mr. Chris Munyela is part of the meeting, who is the BRP for Optimum. And also we have Mr. Bowe Faniker, who is the lawyer representing the BRPs. Now, I would not want to give a detailed background around this matter because we have the BRPs who are also responsible for the running of the mine. But what we have done from the side of the department, we have prepared a detailed presentation that we're not going to go into detail, but we thought that it would be appropriate for us to provide honorable members with sufficient information. Now, the Deputy Director General responsible for communal regulation, Advocate Susan Malebe, will be taking us through the presentation. Then after we have presented, Chair, I will request the BRPs, Howard, Mr. Vantage actually, and also Mr. Munyela to come in. Thank you very much, Chair. I will now hand over to the advocate just to run through the presentation because you are, of course, indeed correct, Chair, that you are familiar with this presentation. We touch on key issues only. Thank you very much. Over to you, Advocate.
Good morning, Honorable Chair. Good morning, honorable members of Parliament. Good morning to the DG, DDG's colleagues. Our presentation is as follows on Optimum. The next slide, please. That is the background of our presentation. Next slide. As a background or history, go back to the background, the previous slide. Yes, thanks. As a background to Optimum Mines, we are just reminding the community that this is a mine that was previously, the next slide, owned by BEXA, and it was later transferred to Optimum in terms of the Section 11. And then the asset included Optimum Coal Mine, Brakfontein, Korenfontein Mine, and Idwala. And then later on, Optimum Coal Mine was acquired by Tegeta Group of companies through a Section 11 with Lenco in 2016. The next slide. And then Optimum held various rights, mining rights in the department, and those were later consolidated into one mining right that went to Tegeta, and it was granted from 2018 to 4 June 2020. So there's still potential on the mine. And when Tegeta acquired the operation, they had to resume all the environmental management issues, the mine economics, and the social and labor plan commitments of the old Lenco. And then we were informed on the 1st of March 2018 that Optimum was placed under business rescue. Next slide. In terms of the SLP, at that time, Optimum had an SLP which was approved as part of the mining right. And then as part of the SLP guidelines, the SLP is reviewed every 5 years in line with the IDP of the municipality. And then those are the cycles of the Optimum SLPs that were implemented. You will realize that the first cycle of 2008-2012 was implemented successfully by the then holder Glencore. The second one was approved but was not implemented by Tegeta. And then the one that is long overdue has not been submitted by whoever, either Tegeta or the BRPs. The next slide. Again, in terms of the SLP, the next slide.
Yeah,
again, in terms of.
I mean, it's it's hard with the Zoom to stop. It is, and then they can't hear you, and then they don't understand. Okay, Optimum is now. Yeah. Do you want to listen? No. What's happening now? What's happening now? No, exactly. Yeah, Mo was saying, Mo actually sent a message to a comment. What? Can you please, those who are not in the background, switch off your mics, please, and then start your fight on your own out there. Please don't disrupt the meeting. You were saying
in terms of the SLP, Chair, can I carry on?
Apologies, Chair. I'm trying to mute the people that are talking, but they're busy unmuting themselves. Can they please mute?
To see that Optimum people are presenting. They don't show the presentation on the TV or the live stream. But we didn't even get it. There was
Yeah,
nothing.
we don't want to hear those discussions at the background.
It's playing live and it's running, but there's no.
Yeah, but I think.
Okay.
I think was this not is Mo?
Ayanda, mute all, and then the speaker can unmute again.
Okay, Ari, that's what I'm gonna do because I'm trying to unmute them. They keep on muting themselves.
Can you continue?
Okay, Dan, I've muted everyone. Can the speaker please unmute?
Thanks, Chair. I was on slide 6. As I was saying, in terms of the SLP, we conducted an inspection in 2018 just to check what is going on in the company, and it was reported that at that time there were about 500 permanent employees and 1938 contractors. And at that time, the main areas of non-compliance were the incomplete local economic development projects and the backlog on the implementation of the human resource development programs. And as a result of those non-compliances, we issued a Section 93 instructing the company to implement those corrective measures. Next slide. As subsequent to that, we were informed that all employees were placed on special leave in December 2018. And then in 2019 April, their contract of employment were terminated. And in May of 2019, the company was placed under care and maintenance. And the company recommenced mining operations in 2019 in terms of the inspection that we conducted and the information that we received at the mine, and that they are currently employing 80 contract employees who are mining a mini pit. We were also informed that it is predicted that about 120 ex-employees will be recalled by August 2020 to come and mine the additional 2 mini pits. There were delays in the construction of the KwaZama-Kutle community health care, which was done previously by Glencore. And the reason why we're bringing it here, Chair, is because it was visited by the committee at some point. And at that time, there were a lot of issues. The contractor was not paid. The community was up in arms that the clinic is not getting completed. But subsequently, the clinic was completed and then handed over in June 2019. What follows will be pictures of the clinic that has been completed by Glencore and then handed over to the relevant authorities. The next slide will be the environmental liability. In terms of the environmental liability, the financial provision for the year 2016-17 was about 1.5 billion. And during the inspection that we did in 2019, and at that time, the company was already placed under care and maintenance, the environmental liability was estimated to be around 1.8 billion. Now, the company had a trust with the amount of about 1.7 billion, and the said amount was transferred from Bank of Baroda, and then it went to Nedbank, then it was transferred to the department in May 2019. And the amount that is accrued in the departmental trust account, including the interest, is about 1.7 billion. However, there's still a shortfall in terms of our calculations of about 112 million in terms of what is currently going on the site. The next slide. The next slide, please. And continue with the concurrent rehabilitation. The next slide. Optimum was behind with their rehabilitation. And upon, next slide, please. Thanks. Optimum was behind with their rehabilitation. Upon acquiring the assets, Together made a proposal that they will do the backlog of rehabilitation, and we accepted that proposal. And according to that plan, there was a total area of 853.98 hectares that has been disturbed. And at that time, about 1281.93 hectares was available for immediate rehabilitation. And that included the areas where there were offices, ramps, and final voids. And based on the proposal, the company was to conclude the rehabilitation by end of March 2020. And in March 2017, we went for inspection just to check if the concurrent rehabilitation is ongoing or if it has commenced as per the proposal and the commitment. Next slide. It was found that that has not happened, and then a follow-up inspection was done. And then in that follow-up inspection, they confirmed that only 17 hectares had been rehabilitated. And then based on that, we issued them with a notice of non-compliance so that they go and remedy the non-compliance by proceeding or commencing with the rehabilitation. And we requested them in March 18 to go and adjust their time frame for the rehabilitation. Next slide. When we came back on the 5th of June, there were no mining taking place. There was no implementation of the measures of dust management and water monitoring, and there were no measures to prevent any spontaneous combustion at the discussed dump. The next slide. And in terms of statutory reports, Chair, the company had not been submitting the updated or the review of its financial provision, and that's why in terms of our calculation, there is a shortfall. And then we issued them an order in terms of Section 24P of NEMA. And still now the company has not submitted the performance assessment for the approved EMP and the EA. The next slide. And what we did in terms of remedial action, that for them to conclude on the rehabilitation and also on the financial provision, we issued them the Section 31L of NEMA for them to provide reasons why they should not be issued with the final order. And in that order, the issues that we're raising are those that are on the screen, for them to revise the annual financial provision, to submit the performance assessment reports, and also implement measures of dust management and water monitoring, and also prevent spontaneous combustion on the discard dump. The next slide, which is our last slide in conclusion, the company continues to be under business rescue, and the company continues to be non-compliant in terms of the social labor plan and the environmental management program, and the department will continue to monitor the company's compliance. Thank you, Chair.
Thank you very much, Honorable Chair. We still have 7 minutes. I think I need to mute my camera because it is giving a very unpalatable feedback. Chair, with your indulgence for the next 7 minutes, I would like to invite Mr. Bower at a high level to take members through the issues where we are now as far as Optimum is concerned. Over to you, Mr. Vanike.
Thank you very much, DG. Thank you. Good morning, Honourable Chair, Honourable members. To understand where we are at the moment in our process, I think it is important, just as a bit of background, to understand the state of the mine that the business rescue practitioners found it in. And that was that there was desperate need for capital investment that was lacking from the time that Tegeta took over the operations. So from the first day, two things were clear. First of all, capital investment was required, and second of all, the end game, if I might call it that, could not be one where the company is turned around and handed back to the shareholders. And the reason for that is quite simple. The reason, especially the one given by the directors at the time, why the company was placed into business rescue is because the company could not obtain any transactional banking facilities, and as things stand at the moment, still that appears to be chances of that happening in future appears to be non-existent. Right. So you need to have a situation where you sell the mine, alternatively where you operate the mine, and by generating income, pay off the creditors, which are substantial. So the practitioners went through a sales process, in fact more than one, over the last 2 years. Currently, as we sit here, there are 3 bids on the table. The difficulty that the practitioners, the company, the creditors, everybody faces is assurances regarding the funding of the mine. As you will appreciate, Optimum is a big mine. It requires a lot of money to ramp up, and in the current market, there are very limited players who have the capital to acquire an asset of this size, especially if you need to ramp it up. And obviously the arrival of COVID-19 has made it more problematic. That being said, the practitioners are considering it, and they are also considering an alternative plan, the alternative plan being to, at least for the next couple of years, commence with a ramping up of the mine to get it up and running again and in production. That partly has started. The mine is in care and maintenance, but the care and maintenance costs are also substantial. So to make sure that the mine can carry those costs, it is appointed 2 contractors to do mini pit mining, i.e. Mine areas outside the life of mine, to generate income, and they are in talks with 2 further companies to do that. That is the purpose of the contracts are to fulfill the care and maintenance requirements, but also to slowly re-employ ex-employees and members of the surrounding communities insofar as it is possible. We are expecting an alternative proposal from one of the largest creditors in respect of ramping up the mine. We believe that this will be coupled with suggestion for a business rescue plan to convert a large amount of debt into equity. Exactly how that will be structured, we are unsure of. We hope to have clarity on that during the course of this week. So that is where we currently stand. Coupled with that proposal, we'll probably, or when we receive that, it will probably put us in a position, put the practitioners in a position to publish a business rescue plan. But that is very much dependent on what transpires during the course of this week. That, I think, in short, is where we are at the moment. Chris, I don't know if you want to add something to that, but if there are specific questions, obviously, we will try and answer that as crisply as possible.
Thank you very much, Mr. Van Niekerk. Chair and honourable members, for record purposes, I must also confirm that from the side of the BRPs in attendance, we also have Mr. Kert, as well as Lilly that also part of the meeting. Chair, it is 5 to 11. I think we have managed to adhere to your directive. I would like to hand over to you, Chair. Thank you very much.
Thank you, DG. I don't know what's happening to your mic this time around, but it's not good at all. I don't know whether it's your earphones that you have put on. They are missing the link between your gadget and their programming. But good as it may, honourable members, there is the report. Let me not say nothing much, but DG, I'll better reserve my observation, except to say that I'm just imagining sitting here, what would happen if all the mines were to go under business rescue? What would be the role of the department? It's just a thought in me. If we were to get almost 50% of the mines in DMRE being under business rescue, what would happen? But let me not, I would have wanted to summarize, but let me be fair to my members. Can we, members, try and, if possible, not even go for the 3 minutes that were given? Let me start from the other side. Honorable Kula, do you have any take? I hope you have not disappeared. Honorable Kula. Can you unmute? Is Honorable Kula in here? I don't want to go back and check members that they still in. That's what made me disappear last time.
I don't see him,
Honorable
Chair.
Phillips, any take, Honorable Phillips? Is Honorable Phillips in?
Yes, Chair, she is in.
Can you unmute Honorable Phillips and then say you're okay? If you're okay, or...
Sorry, Chair, just to indicate Mr. Volmarans is in.
Okay. Honorable Mtenjana, any take whilst we're waiting for other members? Honorable Mtenjana?
Yes, Chairperson. Thank you very much, Chairperson, also for the opportunity. Yeah, Chairperson, from where I sit here, there are more questions than answers here in this issue. Since the mine was placed under business rescue from March 2018, it was just a mess. I just wonder, actually, well, I don't know, maybe the idea of the government to introduce this business rescue system was for the good, but I don't see anything. I don't see any help whatsoever from any business rescue, any property or any company that is under a business rescue. It's just a mess. And it's a shame because all these things, Chairperson, it's happening. It's costing our people, the workers. For example, in this issue of the Optimum, since the so-called Guptas and all those things have messed up everything, it's just a mess, Chairperson, because we're talking about the people here. There were people who were working on these mines. As we speak now, I will tell you, Chairperson, there is still a report that there are a lot of workers which were working on this. It's just a mess. People are still not got paid of their monies from 3-4 years now. I don't know what's happening with them. Chairperson, all I can say, yeah, really, this issue of business rescue is just a problem. It's a serious problem. It's just a mess. I don't know this department, how can it intervene, or how can we come in between, or the department come in between these issues of business rescues? Because everywhere there's a business rescue, it seems that these business rescuers are just here for their own benefit. They are not here to help anyone, not anyone whatsoever, not the community, not the workers, not anything. Chairperson, I've got nothing to say. This thing is just a mess. Thank you.
Thank you very much, Honorable Volmarans. Honorable Volmarans.
Chairperson, thanks for the opportunity, Chair. I would not like to delve much because I found the presentation already ongoing with the problems that I've had. And if the matter that I'm raising is a small matter, if it has been covered, I would be fine. I raised it before that the business rescue practitioners and their emoluments or their own salaries or invoices versus the salaries currently of the employees. I think from the business rescue practitioner side, they might be getting their invoices, but on the salaries of the employees, I'm not 100% sure. I am of the impression that they are not getting anything. And that is giving me a problem. If that is the case, I would want them maybe to talk about their remuneration versus the remuneration of employees within this difficult business rescue operation. What are the mitigating factors for and against, and what needs to be done? Whilst we say there's no money and we are trying to make sure that the business comes back, I am under a strong belief that in terms of their professional fees and so on, they are being remunerated. But Chair, that is the comment that I have for now, Chairperson.
Okay, Honorable Newman.
Thanks, Chair, and honorable members. Chair, I do not have a take per se, but my worry, Chair, is something that we have raised before in this portfolio committee. To say that, each and every time we've got business rescue practitioners, they seem not to be rescuing the business that they are supposed to be rescuing in order for them to continue collecting revenue from the process of rescuing a business. So really, we must actually find a way, like Honorable Mtengane was indicating now, that it's a total mess where you've got business rescuers. Because even the intention from them to rescue those business, I don't think it is what government had initiated business rescue practitioners for. It does not bring any results because their main form of collecting of revenue will be to say, as long as we stay, even if sometimes they have to extend, it's like having an administrator in a municipality, because those people have no intention of leaving a municipality because their main intention is to put the invoices. So the willingness of the business rescuers really is very doubtful at this stage, and we must also start to debate their existence and why do we put business rescue practitioners into state entities. Thanks, Chair.
Okay. I accept if Honorable Mpumalanga has been calling him, is not responding. Honorable Maling.
Finally, Chair.
My apologies. My apologies on the past one.
Good morning, Chairperson, and good morning to our guests. Chair, let me register my disappointment on the behavior of our guests. You see, we are on virtual platform. We are still a committee of parliament. So the decorum of the committee should be upheld all the time. Chairperson, let me join my colleagues in my confusion. You see, today I have never attended a PC that confuses me like this one today, because both the presenters that are here, they are just not doing okay. And I am also wondering, Chairperson, as per the sentiment that you have just said, with what will happen to DMRE if all mines will be under business rescue practitioner? Have they internalized this as a department? What causes these mines to go under business rescue practitioners? Because immediately these mines get into business rescue practitioners, the department ceases to be in full control, except that they are the holders of these mines. Chairperson, you can see from the Optimum that is presenting now, they are making money, but they are not paying employees. They retrenched employees sometimes. December, they gave them special leave in December, 18 April, they were laid off. They had about 550 employees there. Now they have 80 contract employees. Has the resources in that mine been depleted that they can only employ 80 people? And have these people that have been laid off been paid? Because they were writing to you to say, help us, PC of Parliament. We haven't been paid. What is happening here? These BRPs, they are not going to assist in terms of reducing unemployment in this country. Thank you very much, Chair.
Honorable Sanyan.
Thank you very much, Chairperson. Well, my colleagues have covered me deeply on how I feel about the business rescuers. And, I wish one day, Chairperson, maybe we can have an example where these business rescuers are actually rescuing something, because I don't understand why the company is not even complying with the SLP and the ENPR when the business rescuers are there themselves. And then they knew that they were coming to this meeting, but everything is postponed to somewhere this week. There is no clear plan exactly on what route is going to be taken. Is it the route of actually making sure that the mine goes back into full operation, or is it the route of selling the mine? I think today, members, we have been so confused. From the first presentation to the second presentation, we are just left confused. And we're supposed to make decisions, and it's very difficult for us to make these decisions when the information that is given is like this. Again, I go back to the department and say, DG, can you tell us when things are like this, your plan of action is what? And again, Chairperson, maybe we should look into the issues of how are we going to deal with such issues legally. Most of our mines are in the hands of the people who do not care about the employment of the people. Our mines are in the hands of people who just don't care about the communities where those mines are. And the question is, how long as the state are we going to just watch our properties? Because these mines are our properties in the end of the day. How long are we just going to sit, DG, and just accept what is happening and keep on saying our hands are tied? So maybe the department can actually give us a proper plan on how are we going to deal with this issue. Thank you, Chair.
Okay, Honorable Mailam.
Thank you, Chairperson. Chairperson, a couple of questions. My first question is, who currently owns Optimum? It seems to have gotten confused when there was a bid by Charles King to get his assets, but I'm unclear as to who the current owner actually is. I heard you say that a large creditor would possibly convert debt to equity and that you were expecting a response on this week. Now, while that's obviously a welcome development in that there is progress being made, it won't actually result in a capital inflow. So where would the money that is required for that capital investment that you're looking for be coming from? Are there any other potential investors in Optimum that would be looking to purchase the assets and resuscitate the mine? And if there are, what sort of time frame are we looking at to hand this mine back as an operating or as a going concern? Thank you, Chair.
Babu Masaule.
Thanks very much, Chair. Maybe to just pick from where Honorable Malam left, to say we are told that there are suggestions that on the business rescue plan, there will be a convert of debt into equity. I'm very happy with the question Honorable Malam is asking. But on top of that, I would want to ask, since 2018 March, when business rescue practitioners were appointed, why is it now, after 2 years, that they're only thinking of such suggestions? Where I'm going, Chair, is that when you are a business, maybe to really get where Honorable Zwide was going, to say it's time we put business rescuers or business rescue practitioners into a scrutiny to say, what are they? What do they do? Because you can't be appointed 2 years later, you have not moved and you don't know how to move. You are still contemplating on a plan. You don't have a plan. You are contemplating on a plan. My understanding is that if you are a business rescue practitioner, you are there to rescue a business. And therefore, there must be a time frame. Why is it that the board of, for instance, SAA is given time frames to say, at this particular time, you must have turned around the company. But when you appoint business practitioners, there is no time frame to say, at this particular point, you must have rescued this business, otherwise you are going. And therefore, that it creates a continuous non-rescue of a business by business rescuers that are supposed to be rescuing businesses. Now, the question would be, and I don't know where it's going, whether it's going to the department or it's going where, what is the time frame of those business rescuers or practitioners in that Tegeta or Optimum? When is the time frame? Because the question asked by, I think, Comrade Honorable Mchenjan or somebody else about the payments that business practitioners are receiving. You can't set your own contract to say you are going to be a business practitioner for 5 years while you are getting paid from the same company that you are saying it does not have money. It just can't be. Maybe we need to put really into scrutiny these business practitioners. What are they? What are their roles? Across board, not only in this particular rescuer that they were supposed to perform here. Thank you very much, Chair.
Okay, I will come back to some of the issues that were raised. Maybe let me be fair. I know we members, we still have got more work. I can tell you now. I will come back. DJ, 5 minutes, 5 minutes. By 25 past, bring back my robes to me. Can you respond to the matters that members have raised?
Chair, maybe
So
before
including the business rescue practitioner.
Chairperson.
Yes, ma'am.
Maybe before that, man, there is a point that I lost, and let me abuse you because I did not speak on the first part because of confusion. Chair, when you have a municipality that is collapsing, you invite what you call administrators, which I think they're equivalent to business rescuers. When they ascend into a municipality and they do their work, they draw a salary, Chair, not an invoice. Why is it that business rescue practitioners are given the option of invoices, not a salary? I don't know who is going to answer that before. Maybe the department can assist us. I don't know.
You really hijacked me. DJ?
Thank you very much, Honorable Chair. I tried to change my gadget. I'm sure I'm audible right now. Chair, I think okay, no, thank you very much, and honorable members. There are one or two questions that have been directed to the department. Obviously, every time the question that comes up is, what are you doing as a department in dealing with this matter? Chair, you know, it must not sound as if it's an excuse. I think the DDG has presented in terms of the law when a mining company has failed to comply with the mine works program or be it SLPs, what we are required to do as a department. Now, we have been able as a department, whenever there were non-compliance issues, now we're able to, apply the law as the DDG has presented. I thought that I should clarify this point. Now, the other issue, Chair, that members have raised, which honorable members are quite correct in what they have just raised, is the role of the department again, in as far as this process is concerned. I think, Chair, in the beginning, we should have explained that. Remember, we had two mines, actually, that these BRPs that are now in this meeting were responsible for. The first mine was Fontaine. In fact, they are still responsible up until the transaction is concluded. Now, that process, I think that is only one method that has been achieved. Now, as a department, we have also played a role. It must be understood that we engage BRPs on a weekly basis, seeking a clarity in terms of the process. Everything that we are doing as government, we are regulated by the law as well, and we understand that we need to push much harder. Now, the Companies Act, I don't want to say that we are not responsible for the administration of the Companies Act, which the BRPs are appointed in terms of. Now, what we have done, based on that, we have tried to bring these BRPs closer. That is why even on the first mine, which is Fontaine, they were able to conclude this process. But what is frustrating, and this is actually the nature of our democracy that I think we need also to appreciate, we have the courts. Whenever you move a step forward any party that feels that it is aggrieved by your decision, it will run to the court. And so this is what has been happening as well in as far as this process is concerned. Whenever we push the BRPs very hard, they will tell us that, the department, this is where we are at, we are trying, but we are having a challenge with the following parties that have taken us to the courts. And so that is one other thing. And so I can't say that it's a problem, because I'll be undermining the role of other, arm of, branch. And so, but from our side, we have noted the concerns that have been raised. That is why we have now managed to finalize the first matter of Gorenfontein. We are processing the Section 11 on Gorenfontein. Now we are on Optimum, and we are still pushing these BRPs very hard to make sure that this process is concluded. The concerns that you have raised, you have been very consistent, and also you have given it the proper context that it is not only with these ones, but where you have BRPs, you always have this kind of challenges. Now, in terms of the question by Honorable Mika, that the administrators in municipalities vis-a-vis the BRPs, I think at that point, it is also regulated by the Companies Act. And so as a department, we don't really have a local stand over the salaries of the BRPs. But if there is a need for the amendment of the law, I think members are empowered to do that, but we must raise a concern as well as a department that we have found that here there is a lacuna in law in as far as this matter is concerned, but it's a conversation that we can have with the portfolio committee. And so I think other questions, if the DDG would want to come in, Chair, can come in, and thereafter we'll give over to the BRPs and conclude this first round. DDG, anything from your side?
We don't have all the time, no?
Thanks, DG. You've covered all the questions. Mostly were comments that we've noted. Thanks.
Bower and the team.
Thank you. Thank you, DG. Thank you, members. I will try and be brief and succinct. The first issue that was raised was regarding the BRP invoices vis-a-vis the salaries of the employees. The critical staff currently employed by Optimum are being paid. It is true that the majority of the employees have been retrenched. In terms of Chapter 6 of the Companies Act, they would be the first to be paid if the mine is sold in terms of the waterfall provided for in Section 135 of the Companies Act. BRPs raise invoices. The reason why they raise invoices and are not paid a salary is because that is governed by the Companies Act, read with the regulations. And their remuneration is covered by statute. So they invoice in terms of what the Act provides for and the regulations provide for. It's my understanding that the BRPs haven't taken fees this year. The next comment was that every time there's a business rescue, the business is not rescued. I understand the frustration, but with the greatest respect, the same business rescue practitioners have successfully concluded the sale of Gorenfontein mines that is busy being implemented. A specific provision has been made that the former Gorenfontein employees be re-employed. In that instance, creditors are being paid. The comment on what would happen to the DMRE is not for me to answer. Have resources been depleted so as to not pay employees? No, not at all. Optimum has vast coal resources. The challenge is not limited resources. The challenge is the main challenge is to obtain enough capital investment to recommence with the mining operations. On that point, there was a question as to, or a comment that debt to equity won't cause capital inflow. That is correct. But the major creditor has informed that over and above the debt to equity conversion, it also set aside between 300 and 500 million rand as capital as a capital injection to recommence mining operations. Who currently owns Optimum? Well, Optimum is still currently owned by Tegeta, the 100% shareholder. There was reference to Charles King. Charles King challenged or brought, there was an arbitration in terms of where Charles King wanted a declarator that it legally purchased Tegeta's shares in Optimum, as well as in Koranfontein and Optimum Coal Terminal. They failed. So as matters stand, Tegeta is the 100% shareholder of Optimum. There was a question of how long before the mine is handed over. Well, that depends on when we receive the proposal and can convert that into a business rescue plan. This needn't be a long time. This can happen. At least you can get to a point where you can vote on a plan within a month to 6 weeks. But Optimum being a substantial entity, handing it over within a short period of time, you would appreciate that over and above the sale of a mine, you would require Section 11 approval, you would require the Competition Commission approval, but so that would take time, and it is not that simple to predict how those processes will unfold. There was a question of why is there no time frame to turn a company around? Well, in terms of the Act, you need to publish a business rescue plan within a specified period of time. Respectfully, in Optimum's business rescue, the practitioners within the first couple of months were faced with literally dozens of court cases, dozens of challenges, which appear to have been specifically designed to disrupt the business rescue process, primarily by the previous shareholders. We know who they are. Why only now? Is there this suggestion? Respectfully, this is not a new concept by the practitioners to now ramp up the mine. Since the commencement of business rescue, the practitioners have actively been calling for bids for what is termed post-commencement finance. Unfortunately, the amount of finance required is substantial. We're talking about hundreds of millions of rands, and there simply are not that many players out there that can do that. They did obtain post-commencement finance as a fact at the beginning of the proceedings, and that kept the operations going throughout 2018. But they were then simply faced with a scenario where additional finance was required, and dozens of attempts have been made to obtain that. To date, that has not come to fruition, and it must be understood that in a business rescue process, you need to engage with your creditors, and if you Optimum is a mine where there are no secured creditors. So if you talk to financiers, in principle there would be financiers, but they would require security for their finance, And the major creditors have taken issue with the fact that, well, we have an unencumbered asset, and now you want to raise a couple of 100 million rand in finance, and you want to set up the mining assets as security. That is problematic, and I can understand why it is problematic for creditors, but that is the scenario that you face here. That is so. Why business rescue? Well, respectfully, Optimum is a valuable asset. Its mining right alone is a very valuable asset, and together with Optimum, you have Optimum Coal Terminal that has the export allocation. I understand the frustration of the committee, but I want to make the last point. If you do not succeed in business rescue, you need to liquidate the mine, and if you liquidate the mine, you lose a substantial amount of value of the companies. That would be catastrophic. My apologies.
Okay, thank you very much. I now let me try and wrap up this, and hope honorable members will see it's not something that will also end today. Let me start and just to explain, DG, why I said I'm imagining. And I want to make these things because we're gonna need it. I think when we deal with even this one, we'll need this report. One, because the confusion is that, let's be frank and honest and upfront and be clear. The issue of Optimum and other mines, including the uranium one, was based on the fact that the Gupta family's bank accounts were, what I want to use, were freezed, whatever you call it. And therefore, they did not have a banking facility. And this is the question that was asked from the word go. When you bring in a business rescue practitioner, where are you going to bank? Because they don't have a banking facility. Secondly, the condition was that, you understand, is that in order for you to own a mining right and a mining license, you must have a bank account or a banking facility, and the department must know and must be aware that the specific amount allows you that you can own a mining right and a mining license. At what point does the banking facility lapses to be a requirement for you to own a banking license? It's very important that when we come back, these answers must be clear and be given. Thirdly, at what point do you appoint business rescue practitioners and be appointed by the same creditors or directors that don't have a banking facility? It's important just to get an answer. At what point isn't it indirectly the same people that would have been, again in inverted commas, blocked from trading, being allowed now to trade through a certain facility that does not require the approval of the department? Fifthly, if there is one of the requirements of the department is that in order for you to retain and sustain your mining right or your mining license, you need to comply with specific regulations. Amongst those at the center is mine health and safety. Secondly, critically, is the issue of the issue of the SLP. Thirdly, is the issue that relates to rehabilitation. In the report that has been given, even under the business rescue practitioners, there is non-compliance with those. If we are wrong, please bring us in writing. How far have you? There is a shortfall on the rehabilitation. On what basis? You are applying the section 11 that probably could be in place, but already through the business rescue practitioners, without the decision or the concurrence or reference to the department, they've already taken a decision on debt to equity for one of their creditors. Where does the department feature in all these exercises? We need, DG, I want to be frank and honest. when, as we said with Lilly Mine, can you give us these answers? Are we sitting and give us a list, even the business, give us a list and names of the creditors, and sometimes the creditors are not necessarily the directors. One of the conditions to operate a mine, one of the conditions, you see, this is where another issue, last time honorable members were still receiving that. One of the conditions to operate a mine is that the mine must practice fair labor practice. In this case, there is an application of through whether Section 36, I don't know, I'm not familiar with the Companies Act, but can you prove, can we get an information whether those workers that were retrenched, who issued them with notices of retrenchment, which sections of the law? The last time Labour were here, they were complaining about Section 189. Now, as I'm listening now, it seems there is another section in the Companies Act that allows that workers can be retrenched. I would understand in the MPRDA, which is what they were talking about. Can we get answers on that side? Fourthly, DG, if your problem is the Companies Act, which is not under, I agree under you, courts make a ruling on the basis of what is in the law. Have you contemplated to engage with your counterparts, which is why I was asking, have you contemplated to engage with your counterparts on the possible disharmony between the Companies Act and the MPRDA, on the basis that the application for license and everything is under the MPRDA, but the decision to rescind the authority of the department over a mining right only lies with the Companies Act through the business rescue practitioners. If yourself you make that concession, don't you think it is high time you engage your counterparts under the DTI to harmonize the two? Because as far as I'll be frank and honest, it seems to me the moment the business rescue practitioners kicked in, the department is completely collapses to have authority and power over how to run the mine. And the big question will be, if a disaster were to happen in a mine that is under business rescue practitioner, what will be the response and the reaction of the department? So I'm saying, please give us all these answers. Tell us who are, and I think the most critical thing is not just the invoice. How do you, because amongst other things, companies must have up-to-date financial accountability mechanisms, whether financial statements and so forth. I think that's the point Honorable Melam also had raised in the initial submission. Who does the books under the business rescue practitioners to ensure that there is compliance? And who makes, I see the invoice, because there is mining, if I'm listening, that is taking place there. But the question is who authorized it to take place? It's export-based, and there is an extension of a life of mine. To what extent is the department involved? So I want again to make a similar thing, because we're still gonna, as we speak, there are workers that have been out of jobs, there are workers that have not been paid for so many days, which I don't think is a condition that is allowed to run, even if it's business rescue practitioners. We hear the retrenchment, but what about the period that they have not been paid their wages and salaries? Where does the department come in? Please give us these answers. If you want us to send you all those questions, we will do so. I'll ask the staff to do so, DG. And when we discuss, we want to be more informed. We must be clear. I don't want to go with the hype. There's no one who's anti-Sorenso. But we must know who is these people that we are talking about when we say creditors. Who are those creditors? Who are these people that are driving the mine when they are no longer in control? Is it because of the fact that they don't have a banking facility? Initially, it was denied. So we must get this thing. Who are these creditors we are talking about? I know maybe workers and those that may have an interest that were not paid as suppliers and so forth. That I understand, but there would be people who are creditors on the basis of being directors of the company. When we have that discussion, we must be able to assess whether the department itself is exercising its authority. And if it is not exercising its authority, is it worried about the fact that it cannot exercise its authority? And what is it doing about that? I'm not against DG, but I am very uncomfortable that every time we are going to sit here, to me, it's like the business rescue practitioners are the most untouchable creatures in business. So we must know, the department must be clear that in some cases, we are only solely dependent on what they have, and we don't have authority on what we have given a company, not them. Can we then say, honorable members, we will send those questions if the department is not aware, and if it requires answers from the DG, we will do the similar exercise, we will compile a report, including on the issue. I'm sitting here, I don't agree with the business practitioner on the question of the business rescue plan in terms of how it is regulated, but it's fine, that's their view. We will deal with that as and when. Can we then agree that when these things are sent, we will do, in as much as you might be on recess, we will do everything possible that members, they get those questions or those answers, and then we will have a discussion on what is the committee's stance. I said we dealt with Lilly, and what do we recommend, and what is our stance when it comes to Optimum. That is supposed to be done. If we say, I will throw our hands, there's nothing we can do, that's what we will do. Can we agree on that one?
Yes, Chair.
Can I ask honorable members that those members who will feel, maybe even after the meeting, there are more other, so that we don't start that discussion in the committee. Those who feel that there are other questions they will want the department and the business rescue practitioners, both in Lilly Mine and in Optimum. Please try and send them in advance so that we can send to the department as they compile the response and we go for discussions. We know that almost all the questions have been are in front of us. If we agree on that, can we go to the last item, honorable members? For now, I know I doubt we'll do the minutes. Can we go to the last item very quick? No, the department and the business rescue practitioners and Mr. Arendse, if he's still here, they are released if they want to go. Honorable members, we have forwarded you the what is this? The program for the third quarter for your attention and get a feedback from yourselves. Point one. Secondly, I asked the committee staff to also forward so that there is an understanding on how we do what you call the focus areas as guided by the House Chairperson. Thirdly, I forwarded the manner, the responsibility on how to run virtual meetings. Fourthly, I would ask also the secretary, both secretaries, we received a letter. Maybe Ayanda and Ari can post them. A letter from Honorable Milem before, which was requesting if possible, both those letters, which was requesting an urgent meeting on the issue of the shortage of diesel in the inland. And subsequently, I think last week again, we got another urgent letter that was asking for an urgent to, what do you call this thing? To deal with the issue of the nuclear being conducted by the department. I would ask the secretaries to flag those The reason we put it here, honorable members, as I'm going to say the last thing, the reason we put it here is that when we dropped the program, I didn't want us to lock those outside because they are called urgent. I wanted that we take into consideration that there has been a request on those matters. Lastly, maybe now I will ask Ari in 2 minutes just to explain the issue of placing matters, including the ones that we agree, in terms of the virtual meetings, what is expected when we place items on the agenda, including the ones that we have through the virtual meetings. Ari, can you do in 2 minutes the procedure, normal procedure?
I didn't get that correctly, Chair. What do you want me to explain?
I'm saying the normal procedure currently through the virtual meetings when we want to place items on the agenda, on the agenda for the committee. Ari is still locked. Honorable members, the simplest thing that we must explain is that when we put items on the agenda, I think it's important to say this. The application, if the committee has agreed, first the committee must agree, and the chairperson must sign a letter of approval that he knows the agenda item, including if it is a program. Secondly, is that we are limited to our own slot, and as a portfolio committee on mineral resources and energy, our slot is Tuesday. Thirdly, is that we must stick to that slot. If we make a motivation, we must make a motivation, but that motivation will be subject to the availability of slot. I thought it's important to raise that matter, and therefore, if there is an item, it means we must then replace. You can only do a replacement of the item or on the slot approved and put an alternative item to it in order to be considered. The reason I was saying then the other things must be forwarded. There it's clear, mostly we only have got one slot. Secondly is that if we got a second slot, it will be on the basis of our motivation for that slot and whether it's not in competition with other slots. So I thought I must. That is the point I was saying. Ari must do. It is not automatic when we agree here that that date we agree on is confirmed. It is confirmed as far as the program is concerned, but the slots are still a subject to the approval in the pool. That is what I think I said. Can I then place the issues, honorable members, in terms of the program and then the request that have been made in relation to urgent matters? This is our last meeting, by the way, today. We must also note that. Very quick.
Person. Chairperson.
Sorry, Honorable Milam.
Chairperson, I'd just like to point out that I have no problem with the program. The request for a briefing on the nuclear issue was not an urgent briefing. It was just to be slotted into the program when we can find a slot for it. But the diesel issue was and is urgent because there is a crisis brewing in our country with regard to a diesel shortage.
Chair.
Oh, okay. Honorable, is that Honorable Mashauda?
Yes, Chair. I would really, what is the better way to put it? Unfortunately, this point, Chair, is being discussed, or it's being proposed that we discuss it at the time where we have read some of the reports in the media that there is a shortage of diesel and all of that. And if the response of the department is to go by, it then says to us, what we have been worried about of shortage, they have put us in ease with their response that I saw in one of the media articles that I'm not going to read it, but it acknowledges that there is sufficient product available for South African market. Now I'm just weighing what is in the program now and the agency of the diesel issue, which I don't want to really say it's not urgent, but the department wrote in one article that it has noted concerns of the shortage of diesel, which were reported in some media. The department wishes to confirm that there is sufficient product available for South African market. However, logistical challenges are being experienced partly as a result of reported tampering with the pipeline network, either through attempted theft or actual theft of fuel. That is one paragraph from that statement, which, in my view, takes away that urgent need to really put this in the program now. But it doesn't take away the fact that in the next coming batch of program, we can include this point, because it also speaks about the tampering of pipeline network, which is a problem. But I don't see a need to really slot it and replace something that we had planned before. Remember, we have been cancelling some of the issues that we have been saying they are urgent. One would be, we should have gone to Petro SA because we are told that it's coming to an end in 2020. We undertook that we must go there. Lilly Mine remains an urgent matter to us. We had Zamazamas that we said we are going to visit because people are killing each other. Army people who are well trained are killing police in the mines when trying to protect their terrain. So the agency, if we were to really weigh the agency, I would say at least the department on this one has put us at ease. But let's find time. It may not be now, later on, to really have the department coming to explain it. Thank you very much.
Chairperson.
Honorable member, wait, Honorable, can I suggest the following so that I don't think I take the point that Honorable Mashal and Honorable Malam are saying. I assumed, accept my apology, Honorable Malam, I assumed also the issue of the what to call it, the nuclear program was an urgent matter, but I don't think we can sit in dispute on that. Can we do the following? Agree that because today there is no other meeting that will take place, as we are going to. I take the point Honorable Mashal is saying, but the problem is it doesn't come to the committee. Can you allow me or allow the chair to write to the department and say, we have noted that there is an issue that seems to be a crisis, in particular in the inland on diesel. Can the department give us a take on what is happening and what action is it being taken if that information is correct? When we come back, remember that issue for me, it will also fall directly on what now we can't do again today, adopting the minutes that we did with the committee on select committee of the NCOP, and then say, even if it is not slotted, when we deal with the minutes as one of the outstanding items, we will then take that response of the department and have a discussion on what the department has said. If then there is a need for the department to still be invited and that matter still exists, then the department will have to account, or we can say that when we deal with those minutes, we will want the department also to come and brief based on what they had said, that everything at that time was taken care of. Because between now and that period where we open, was definitely one of these things. Secondly, let's agree in principle that we agree that the department, maybe we will find a slot. I think somewhere where we said Saneti will brief with the grid, that the department must also be given to brief in terms of the issue of nuclear in the national grid and have a discussion at that level. Will that not sufficient? If you look in terms of, is it July 29, we put that item Honorable Mailam is talking about. And then on the issue of the 28th, which we might be dealing, still the department will be coming in. We can slot in what the point that Honorable, but in the meantime, the department must be giving us so that we can see whether that action that Honorable Marshall is talking about, for now, it's not coming to the committee. It was just a statement. Do we agree? Can't we agree on that one and then go with the program? Honorable Mailam.
Thank you. Thank you, Chair. First of all, let me state that the reason for the urgency, and I'd like to point out that I wrote this letter on the 10th of June, on the 9th of June. I know you only received it on the 10th, but it was written on the 9th of June, highlighting the crisis in the diesel distribution. And I'm very clear on the situation that it's not about production at this stage, it's about logistics and distribution. But the reality is, Chairperson, that we have a crisis in that large parts of the country are not able to obtain diesel. And it's particularly affecting the agricultural sector, the long-distance trucking sector, and the mining sector, who require diesel to operate their machines. Now, in the agricultural sector in particular, we're at the height of the harvest season. The grain farmers are expecting the biggest crop they've had in many years, and they are unable to obtain diesel. And this is the information that I'm receiving from people across the length and breadth of South Africa. I received it from Limpopo over the weekend. Last week it was Gauteng. Now, all of this says to me that we have a real crisis, and it's not something that we can postpone or come back to at a later stage. We need to deal with it with the urgency that it deserves. And frankly, the department and the minister said when I raised this during the APP that everything would be resolved by the end of May. Well, we're now nearly at the end of June, and it hasn't been resolved. And that's why I think we need to deal with it urgently. It's part of our oversight responsibilities when a matter arises that is affecting broad swaths of the country, that we deal with it appropriately and deal with it with the urgency that it deserves.
So can I get you on I don't think, Honorable Marshall, I don't think Francis was saying we should. Can I get it to you, because we're left with 2 minutes now. The point is that we have been given that today for us is the last day. Tomorrow we're meeting with public enterprise. Parliament is going on recess. Point one. Point two, like you say, I never received the letter, but when I saw the letter, any matter that is requested to be discussed, the chairperson won't take a decision. He brings it to the committee, and I'm doing exactly that. Here is an item. Last week I did say I wanted to put the item on the agenda, but time was against us. We finished even very late. I don't want us even now, we don't deal with the matter. Thirdly, I'm saying it will mean if it's agriculture, is all those things which it could include Transnet, that agriculture then must commit on agriculture, must have also the similar thing that their members are affected, equally for us in mining. So my take was simple. Let's write to the department and say, what is this response? And then from there, if we are able to meet, we're then able to send that, because that's why I said I'm explaining now the simplest procedure. It means we must go back to the House chairperson. If members say we must do so, we can do so and say we need a special sitting of this committee to deal with this matter. But the committee, the House chairperson may say, bring something that is concrete to me that says these were the concerns that we raised. But if we were to get the response from the department, it must give us a platform then to say we are taking the matter up. At this stage, it is not us who ask to meet, it is the nature of the meetings, which is the virtual meetings, that becomes the first issue as a challenge.
Chair, I note that
Yes.
we've got the discussion on strategic stocks coming up, and I would ask that this be included in that that discussion, and that my concerns about the lack of urgency on this matter be noted, and that that it be dealt with appropriately. I will be referring the matter to the Chair of Chairs, because I do believe that we are not dealing with urgent matters appropriately. Chair, then I'd like to raise a point of privilege, if I may.
Okay, although we are now out of our time.
Chairperson, you issued a press statement last week, Monday, yourself and Mr. Molafo, who is also on this telecon, stating that I was dishonorable and underhanded, and that statement was put up on the parliamentary website. It was subsequently picked up by media sources. Chairperson, I complained to the media department. I received a letter of apology from Mr. Maloto Motapo, and he said that that kind of discussion was absolutely inappropriate and unacceptable. I'm asking now for a formal apology on this meeting from yourself and Mr. Molafo for calling me dishonorable and underhanded.
I won't do that. Just forget it. Let's just leave that one. I never wrote the statement. I wrote the statement not on behalf of the committee, on my capacity as a chairperson of the committee, whose name was mentioned there. But if you want to write to the committee so that the committee can take a decision on that.
No, Chair, I'm asking you. I'm asking you for an apology.
You are asking in the wrong. You are asking in the wrong platform.
Point of order.
You are asking in the wrong platform.
Chairperson,
Honorable Njani,
we are being abused here. This issue, I raised the issue last time. They said it was not the proper platform, so this is not the proper platform for this.
Sorry, it's a point of privilege. It is a point of privilege, and I expect an apology. Failing which, I will take.
We won't be discussing apologies here. Not in this committee.
Very well. If there is no apology forthcoming, I will then take the appropriate actions that I deem necessary to deal with this matter.
That's okay.
No.
Entitled to that. No. Don't worry, Honorable Member. You are entitled to that, Honorable Member, and I will respect it. Honorable
but as far as your responsibility,
is that Honorable? Yes, is that Honorable?
Yes, Chair. Can I just ask this one question? Am I wrong in thinking that we've got a joint committee tomorrow with public enterprises with regards to ESCOM?
Yes.
Oh, I heard the chair saying that this is our last meeting.
No. As this committee, that one is a joint committee. That is a slot for public enterprise.
All right. No, thanks, Chair. I think I'm covered now. Thank you. Then you can save the apologies elsewhere. I'm covered with what concerned me.
Yeah, Zwida, you are right. They can be sent somewhere else.
We don't have time. Honorable Barans.
No, Chair, I agree.
Yes.
No. I think you closed it because I wanted to get in terms of the article that I also raised, and you cited as the chairperson of the committee. And in that regard, that will be a matter that can be discussed by the committee, but not you singling out. So I thought, as you say, it's the right of every member. Perhaps we should wait for it at the time that it comes through as a committee.
Okay, let's leave that matter, honorable members. I'm comfortable with it. Can we then officially close the meeting? We will be able to meet in July. Any other matters, let's leave them as they are. They are within the right of all of us as members of parliament. On that note, honorable members, have a safe break period, but be careful. The virus is serious. Let's take care of ourselves. Let's assist our communities. Thank you very much.
Thank you.
Chair.
Thanks, Chair.
Thank you very much,
Enrico.
Chair. Adios. Adios.
Enrico.
I'm listening, Mr. Volmarans.
And Ayanda, please stop sabotaging me, please, man.
How did we sabotage you, sir?
No, we can't do that.
You must just buy data.
I have in front of me, I have got 4 gadgets, all of them fully fledged. I'm interchanging between the networks, but today, you are dealing with me.
No, sorry, Dad.
That's out of our hands, Mr. Volmarans.
Mama Linga. Mama Linga.
Mr. Volmarans, try to log on early tomorrow morning, ne?
I try. You see, there's a difference. When you are on Zoom, I don't have problems. When it's this Teams, this Teams has got a problem.
And now you're blaming me and Ayanda for deliberate sabotage.
Yeah.
Okay, no, it's fine. We'll take it.
Sure.
See you, sir. Go well.
Grand.
Miss Lonyana, welcome back, madam. Ayanda, so I'll see you tomorrow.
Sharp, Ari.
See you.
See you.